Start. Para. After considering the rival submissions and perusing the relevant material on record, we find no infirmity in the impugned order of the learned CIT, holding that the miscellaneous income of the taxpayer was eligible for inclusion in the profits of the business for the purpose of computing deduction under Section 80, as rightly held by him. The said income, comprising of sale of scrap, amounts returned back and sale proceeds of spare parts, was directly related to the dominant business of the taxpayer company, and the same therefore represented its operational income, which, as held by income sorry Honorable Bombay High Court in the case of Bangalore Clothing Company (Supra), was entitled for inclusion in the profits of the business for the purpose of computing deduction under Section 80. The said decision of Honorable Bombay High Court thus clearly supports the taxpayer's case on this issue, and the learned CIT (A), in our opinion, was fully justified in deciding the same in favor of the taxpayer, relying thereon. His impugned order on this issue is therefore upheld, and ground number 2 of the Revenue's appeal is accordingly dismissed. Para. Ground number 3 raised by the Revenue in this appeal also has two limbs, that is, inclusion for forex gain in both numerator and denominator for the purpose of computing deduction under Section 10A, and exclusion of the amount of rupees 43.28 lakhs on account of tax withheld with Singapore from the total turnover for the purpose of said computation. Para. Insofar as the second limb of this ground is concerned, relating to exclusion of rupees 43.28 lakhs on account of tax withheld in Singapore from the total turnover, the learned counsel for the taxpayer at the time of hearing before us has considered this issue in favor of the Revenue. Accordingly, the impugned order of the learned CIT on this issue is set aside, and that of the AO is restored. As regards the issue relating to inclusion of forex gain in both numerator and denominator, it is observed that the taxpayer has software development centers at Bangalore, the profit of which are claimed as exempt under Section 10A/10B. While computing the said exemption, the taxpayer company had included foreign exchange fluctuation gain in respect of export proceeds in the profits of the business. According to the AO, the said gain was arising as a result of depreciation in the value of Indian rupees, and the same having no direct nexus with the main export activity. He held that it was liable to be excluded from the profits of the business, despite the fact that the same was includable in the total turnover. Before the learned CIT, it was submitted on behalf of the taxpayer that the foreign exchange gain has a very close nexus with the export activity of the company, relying inter alia on the decision of Delhi bench of ITAT in the case of Srimati Sujata Grover versus DCIT 347. It was contended that the same thus was rightly claimed as part of the eligible profits. After considering the submissions made on behalf of the taxpayer, it was held by the learned CIT that forex gain relating to the export proceedings was the direct result of the export sales, and taking into consideration this close nexus between the two, it was not possible to exclude such gain from the export turnover. He therefore directed AO to include the said gain even in the figure of export turnover for the purpose of computing exemption under section 10A/10B para. We have heard the arguments of both the sides and also perused the relevant material on record. It is observed that this issue has also been raised by the taxpayer in ground 4 of its appeal, being ITA number 1189/2005. At the time of hearing before us, the learned counsel for the taxpayer, however, has not pressed the same, thereby conceding this issue in favor of the revenue. Accordingly, the impugned order of the learned CIT on this issue is set aside, and that of the assessing officer is restored. Ground number 3 of the revenues appeal is thus allowed. Stop.